Right, ladies and gentlemen, I hope you had a good lunch and welcome back to this afternoon's session. Gents, if you could take your seats, please, ladies and gents. Thank you. So we heard this morning, and I think one of the game changers for me this morning has been the input we've had from our corporate clients here. There's clearly a business case for digitalization. There's clearly a demand for digitalization, and there is clearly the appetite to meet that demand from some of the suppliers here. So I hope my feeling like a bit of a marriage broker here is an accurate feeling. I think if we can get the two sides together and get people interacting with each other, that's really what we're about here in the ICC. We've had, as I say, the Electronic Trade Documents Act was passed, came into force in September last year. But as many of you may know, it is only permissive in its provisions. It doesn't say anybody must do anything. And one of the risks of which we were very aware when it did come onto the statute books was that it would sit on the statute books and stay there and nobody would do anything with it. But I'm pleased to say that the legal profession has really played a blinder here and in ensuring that that hasn't happened. And they've not just been the people who say, no, you can't do that because there are 25,000 legal reasons why you can't, but they're actually trying to facilitate it and to encourage the greater use of digital capabilities as enabled by the Act for their clients and indeed for the general trading community. So we're going to cover that point. Really, how can we make the best use of that legal advice and the capabilities of the UK's and global legal professions to really make digital trade a reality. So I'll hand over now to our distinguished panel and the moderator for this session, Guy Pendle, who's the chair of the ICC United Kingdom Arbitration and Alternative Dispute Resolution Committee. Thanks very much, Guy.
Nick, and good afternoon, everybody. It's a pleasure to be here. I am the least distinguished person on this panel, so I will try and keep my comments extremely short so that you can hear the people that you really want to hear from. But I think the reason I'm here is possibly because my practice is international arbitration, and there is a connection to what we're going to talk about now, because we're looking at the post-ETDA landscape, and a lot of that is about how we achieve harmonization globally in order that actually for businesses, they have confidence that there is a level playing field for everyone to operate around the world. And there's a parallel there with international arbitration, because we're going to talk about the UNCITRAL Model Law on Electronic Transferable Records that you might hear us refer to as MOLITA. But one of the most successful UNCITRAL model laws is actually the UNCITRAL Model Law on International Arbitration that has absolutely influenced the way in which most countries have adopted arbitration law in their jurisdiction. And as I say, it's created this incredibly level playing field. So I come from an industry that has already benefited from the approach that UNCITRAL take to the introduction of model laws and how well introduced around the world it can really create that level playing field. So that's all I wanted to say, because I want to get onto our panel very quickly. So I will briefly introduce all of our panel and then we will move on to them. So I'm going to do this in the order in which our speakers will be speaking. And so first we have Luca Castellani, who is joining us remotely, as you can see. He is a legal officer of the Secretariat of the United Nations Commission on International Trade Law, UNCITRAL. And he's important here because he oversaw the preparation of MOLITA. To my left is Professor Martina Farrakani. She is the Associate Professor in Digital Trade at the School of Computing Engineering and Digital Technologies at Teesside University, and is also affiliated with the European University Institute, where she manages the Digital Trade Integration Project. To her left is John Taylor. I think many of you know John, but he's the co-founder and director of the Centre for Applied Sustainable Transition Law, otherwise known, I believe, as CASTLE. And he's also an honourable professor of international finance and trade law at Queen Mary University of London. To John's left is Vashti Maharaj. Vashti is the acting head of the CCA, which some of you may know as the Commonwealth Connectivity Agenda. Vashti will explain a little bit more about that, but that's part of the Commonwealth Secretariat. And last, but by no means least, is the Honourable Dr. Adam Mambi. He's joining remotely. He is a judge of the High Court of Tanzania and a consultant for the Commonwealth on developing the model law on digital trade. I should say, by the way, all of their bios are significantly longer and more impressive than I have just said. But I'm sure that since you're here at a digital trade conference, you'll all be capable of looking them up on LinkedIn and connecting with them afterwards. So I will stop there and hand over to Luca to begin with, perhaps just to set the scene on Melita, and then we will hear from the rest of the panels. Luca.
Thank you very much. Thank you also for not only the kind introduction, but also the kind words on the influence of the UNCITRAL Model Law on arbitration. Indeed, I was involved from the very beginning in the preparation of Melita with the UNCITRAL Working Group 4 and eventually its adoption by the Commission. We all know what is Melita about, but please allow me to say the main goal of Melita is to enable the legal recognition and the use of a special type of commercial documents that incorporate the right to demand payment of money or delivery of goods. In Melita, these are called negotiable documents or instruments. Otherwise, you can call them documents of title. You know, there's different ways of referring to these. Civil law jurisdictions may have other ways of doing that, but the concept is very clear. So you have their bills of lading, bills of exchange, warehouse receipts, checks, promissory notes, and so on and so forth. Now, Melita purpose is clear. Melita is technology neutral. Melita is based on something called functional equivalence, which is a principle that underpins also other UNCITRAL texts in this area. And these texts have been adopted by more than 100 states around the world, which is something useful for Melita uptake. So this functional equivalence approach says, let's look at why we have certain form requirements and how we can reproduce them in an electronic environment. As you all know, if I have a bill of lading, I can transfer that bill of lading by delivery or by delivery and endorsement. The problem, of course, here is to reproduce physical possession of a paper document. Melita sets a few requirements: integrity, singularity, control. The Electronic Trade Documents Act, in my view, and not only my view, it sets the same requirements, but of course, it has a slightly different approach in the sense that instead of talking about functional equivalence, it explicitly says that these documents may be the object of possession. In my view, the practical effect does not change. Now, so far, so good, but what I would like to say in my introduction in light of the current discussions is there is another element to comply with these functional equivalence requirements, which is the use of reliable methods. And there is this discussion on reliability. Melita itself has a list, a non-exhaustive list, an open list of circumstances that may be relevant for assessing the reliability of the method. And also, let's not forget that the agreement of the parties may also be one of those circumstances. And in many cases, in a commercial setting, it will be an important one. As you know, France is adopting Melita, and it's adopting Melita with a law that has already passed the scrutiny at the Assemblée Nationale. Now it's going to the Senate, where it will be discussed in less than 1 month. But it's also adopting and implementing regulation that contains additional elements, many of them taken from Melita and missing in the law itself, but others that do that important work of connecting Melita and relevant EU regulations, in particular two. EIDAS, in the part on the use of qualified trust services, including qualified electronic signatures, and also the EFTI regulation, which is about the submission of trade-related information, especially to public entities like customs. That's very important because it's a blueprint for other EU member states, which have, of course, the same regulations. In particular, Germany. Germany already has adopted legislation some 10 years ago, enabling the use of these electronic transfer records, but it has not been implemented because it needs to have specific guidance in a regulation that now can be adopted thanks to Melita and this work in France. So we'll see also Germany coming along. But more generally, and if I may, I know this statement is very broad, but normally, in my experience, common law jurisdictions are more comfortable in relying on party autonomy for assessment of reliability. Civil law jurisdictions want to have a little bit more of guidance, as we say, ex ante, before the use of the electronic transfer records. And this is perfectly fine with Melita and with the, in general, UNCITRAL text on e-commerce, but we have to combine the two. And in combining the two, we have to make sure that all the results of these combinations are interoperable, so that we can use the same electronic transfer records in the different jurisdictions and have legal effect seamlessly. I would like finally to make just one additional comment on Melita uptake, to say that interest for Melita, of course, we promote Melita everywhere, and thanks to the hard work of people like Vashti, especially in developing countries, because there is a commitment by many to make sure that Melita adoption will not contribute, but will actually reduce the digital divides. But in practice, I mentioned big economies like France and Germany. I would like to add Japan and China. Japan made a commitment adopting Melita for bills of lading by 2025. China is looking in doing the same, again, with respect to bills of lading, because these countries already have systems for promissory notes, electronic promissory notes. And I hear about work starting also in the Republic of Korea. So we do have areas like Europe, like East Asia, where, of course, and let's not forget countries like Thailand, for instance, which is already an advanced stage, and other countries. So we see Melita uptake coming up. So in general, you know, two main themes of these days: the discussion on reliability, which in my opinion is going very well, and also real global uptake. Thank you.
Thank you very much, Luca. And I didn't say this at the beginning, but I may ask questions, but I'm very aware that those of you in the audience may have more pressing questions that are more relevant to your own businesses, and that you may actually be better placed to ask those questions. So feel free to jump in and ask questions as we go. My only request is this, because we've got 5 speakers, is try and make your questions quite short, so that we can fit in as many as possible. Luca, I may come back to you, but I'm just going to go now to Martina. Martina, I think, is going to look at slightly broader and talk about the general trends regarding restrictions and enabling policies relating to digital trade more generally. So Martina, over to you.
Thank you, and good morning, everyone. So my role here is to provide a bit of a bigger picture. We've been all morning talking about the micro perspective of companies facing issues at the border with customs. I'm bringing here a bigger perspective of what's going on globally when it comes to governance of digital trade. And by digital trade, I don't mean paperless trade, so digitalization of customs procedures, but really what's the trade which is now happening the most, so mostly digitally deliverable services, movement of data, so the bigger trends that we see globally. And what we are seeing is a clash of different models of regulating digital trade, which are creating issues in terms of fragmentation of internet, which then trickle down to the economy, to people, and they have an impact on our lives. Over the past 3-4 years, I've been working on mapping regulations across the globe that impact digital trade more broadly. So we don't go into the details of customs regulations, but we look broadly at what are the main policies that have an impact on trade across the globe. And we have a database which is open, so you can use it. It maps regulation in 145 countries. And we look at whether which policies restrict or enable digital trade more broadly. So it's really a big picture of what's going on in these 145 countries. And there you find information about the laws, the articles, and everything. And I wanted to show you a bit of what we find in this database. This is not meant to be read. It's just to show you all the type of policies that we cover. We have 65 different indicators, and these indicators cover policies that apply to ICT goods, which are very important for digital trade. So policies that restrict, for example, the import of telecom equipment in a country. We have policies on data. So personal data protection policies, but also other policies that require data to be stored locally. We have over 250 policies in our database related to just data restrictions, and then policies related to digital services and investment related to digital trade. And here are, and you find more information in this paper. So here are the countries that we cover. So as I was saying, we have 145 countries in. I will show you today the results for 130 countries, which are already online. And the other 15 are coming up very soon. Oops. And just some findings. So to show you what's going on globally in terms of fragmentation. We see a huge diversity in terms of level of restrictiveness across countries. You have China clearly leading the ranking in terms of implementing and heavily regulating all aspects of digital trade. But you also see a lot of activity in East Asia, more generally, in some African economies. You cannot see the colors very well here, but yeah, it shows more or less. And these are the top 10 countries that regulate more heavily digital trade. So you see here India coming up after China with a lot of regulations also coming up in the recent years. Egypt, Indonesia, Vietnam, Russia, Thailand, Saudi Arabia. So it's also quite diverse pool of countries. You have countries in each continent, basically, that have a specific, clear control model over what's going on online. And then a subset of these measures are data restrictions. This is an area that I'm very interested in because restrictions on data do not only impact trade, but they also impact freedom of expression. They impact the freedom of communicating for people, and eventually they enable control of what people say by the government. So I'm very passionate about this area. And here you see a summary of what are the policies included in our database. And again, you see in darker colors, those countries that heavily restrict the transfer of data across borders. And you see China is, again, leading the ranking. And China is these restrictions that then impact also every company that wants to offer services to China because they restrict, for example, the location of taxi user information to be held within the country, health data, but also more broadly, data which is considered to have a potential negative effect on security if it's transferred abroad. And the regulation is, the definition of this is very broad, so potentially applicable to potentially anything. And then, yeah, you have also other countries which are seeing China as an example to follow. For example, in Africa, you have Rwanda, that is, you clearly see that it is inspired by China. You have Vietnam, and yeah, other countries that look at China as an example to follow. And on the other side, here you have another slide just to show you the extent of the diversity of these data policies. Here you see the financial sectors. So mostly these policies apply horizontally to all data, but also you have policies that apply to financial sector, telecom, public, cloud computing. But also some of these policies apply to a specific type of data. So it could be that you have a policy in the financial sector, but to all data within the financial sector. Or you could have policies that apply to health data across all sectors. So anyone processing health data is affected by these policies. And here we have a paper which is coming out in a couple of months that shows all these policies and the sectoral and types of data affected by the policies more specifically. And here, the other side of the coin, which is enabling policies that facilitate integration when it comes to digital trade. And here you see that the European Union is leading in this sense. There are a lot of policies that the European Union implements to facilitate digital trade across all the components I was mentioning, but also some countries in Asia, namely New Zealand and Singapore, that, as we know, like, are very active also at the multilateral level to propose digital trade regulation. And again, here you see quite some diversity across the globe. So the problem here is not just the lack of policies, but also the fact that, as we have been speaking about all day, there is not really interoperability, and there is a lot of heterogeneity between the type of policies and how these policies are implemented across the globe. I believe I have just one last slide with some final comments. So what we see is clearly some more fragmentation across the globe when it comes to restrictions. And unfortunately, we see a lot of new policies coming up that are driven by non-economic objectives. So privacy, security, which are justifying a lot of new policies, which unfortunately we are seeing also in countries like the United States, which is a bit sad. On the other side, we see also more interoperable framework, and the MLTR, I cannot pronounce it, MLTR, is an example of these new frameworks coming forward that could create a platform for more interoperability and more connection across the globe. And we do need continuous empirical evidence to show that these policies matter and they create the restrictions actually are problematic and should be avoided, and that some enabling policies support digital trade and should be supported. And one last point is about the technical research. We have a lot of empirical research looking at digital trade, how this impacts, how some policies impact trade and how they should be avoided. But we need more technical research to promote interoperable standards and bridges between these different types of regulations, which is what I hope we will keep doing at Teesside University, where there is an engineering department that is looking into these issues. Thanks.
Thank you very much, Martina. I'm just going to pose a question perhaps to Martina and Luca, and they may want to answer this from slightly different perspectives. So I guess my question for Luca is, having heard from Martina, as the model law was developed, and I appreciate this was in 2017, but if you've got more up-to-date information on attitudes towards it, do you think that some of those regulatory restrictions that Martina have identified in some jurisdictions are going to be problematic for adoption of MOLITA, or do you feel that MOLITA has been put together in a way that will actually be able to bypass some of those? And the contrary question for Martina is, of the work that you've done, have you looked at the effect to which, for example, UNCITRAL model laws actually help cut through that? So maybe we let Luca go first, and then perhaps Martina, you come back to that.
Thank you. MOLITA deals with commercial documents, and if we look at this from the perspective of the commercial document, regardless of whether it is on paper or in electronic form, basically, you know, there is no obstacle to the circulation of the commercial document itself. The issue comes when looking at the content of the document in electronic form. As I mentioned before, the work that is being done, for instance, in France, the reference to the eIDAS regulation, but UNCITRAL has prepared another model law, which was adopted in 2022, on the use and cross-border recognition of identity management and trust services. And trust services is exactly what we need here, because the definition of trust services is a service that gives assurance of data quality. Now, when we get to assurance of data quality, some of the issues, you know, maybe in Martina's analysis, which is based on old language, you know, RTAs, but that is being repeated because, of course, lawyers don't like to change language. You know, if it ain't broken, don't fix it. So it's what you would find under authentication, but it's still the concept behind is an electronic signature in reality. And so where you have technology neutrality and legal recognition of electronic signatures, again, based on notions coming from UNCITRAL, and that helps. But of course, where we cannot help, because UNCITRAL does not deal with that, is if there is a more fundamental restriction on the data flow. And that's where I very much hope that it will not happen in the interest of trade. And that, it's difficult to find a balance between data privacy, data protection, and data flows. But in the commercial field, I believe that so far we could find some arrangements which are acceptable to all, and that allow information to flow and to facilitate trade.
Thank you, Luca. Martina, anything to add?
Yeah. Well, on this point, actually, I agree with Luca that it will be challenging, and this is one of the biggest challenge ahead, to try to find some interoperable solutions that work for everyone on how to ensure that data still can be transferred across border, and countries feel safe about their privacy and security. And when it comes to commercial data, in theory, there is not so much issues when it comes to privacy. There is some sensitive information perhaps, but potentially it is an area where countries could find a platform to discuss and find common grounds for and promote some interoperable solution in this sense. Yeah. In terms of your question on the empirical research, empirical policy on UNCITRAL model laws, I'm not aware of any policy on any empirical research, but there is empirical research on, for example, the presence of commitments on data flows within FTAs, which does have an impact in the economy. So there is empirical research overall showing that when countries try to create interoperable solutions, they do manage to support trade and digital trade. But then on specific policy, it's also very hard to conduct empirical research when it comes to one specific type of regulation.
If I may add one sentence on the specific policy, sorry, as I know it's difficult because I'm away. In some agreements like RCEP and CPTPP, and also in the digital economy partnership agreements, you have a specific reference to some UNCITRAL texts. And in the DPA, you would have a reference to Melita. In other cases, states don't want to commit to identifying specific tests. And so softer language is used, like the recent digital protocol to the AFCFTA. But in general, I would say that UNCITRAL is fortunate because states have started since the adoption of CPTPP, but also sometimes before, states do make reference to UNCITRAL texts in RTAs. Thank you.
Thank you very much, Luca. And that might be a very good segue into our next speaker. But I'm just going to ask our technical people if they can switch the slide on the screen in front of us so that we can see our other two speakers. But while they're doing that, maybe, John, we can hand over to you. We've heard about Melita. We've already been talking about ETDR. What else?
Well, thank you very much. And a great pleasure to be with you all here this afternoon. You may be wondering why someone who is ascribed to be with a company that emphasizes sustainability should be speaking with you on digital trade matters. Well, it's because Melita opens the door to incredibly sustainable trade, much more sustainable than we currently are facing here in the world today. And that's what was the, as it were, the hook to get my colleague, Dr. Theodora Christou in our audience and I into this field to assist and study this field. I'm going to concentrate just on the legal aspects or the environment that might further facilitate digital trade. I realize that there are many other aspects that need to be addressed, a lot of which were discussed this morning. But for my presentation, I'll rely heavily on what further legally might be done. And please, when I conclude, I'd welcome any comments and observations from you all, because you may be facing aspects in your day-to-day work where still legal obstacles are barring you in some way or another, or dissuading you from going digital in the trade and trade finance area. And it would be very useful to know this. Well, first of all, the first thing that I'd say is it's really important, and I can't underline this too heavily, that all countries, at least all significant trading countries, should adopt the principles of Melita. If they're not actually adopting Melita itself, the text of Melita itself, it's only 4 or 5 pages. I mean, this is incredible. This is not difficult for legislators to get hold of. And it's difficult if you want to translate it, of course, into, of course, you've got to translate it. You've got to translate it into your own domestic law. But it's readily doable. And look at this phenomenal example that the United Kingdom gave. I mean, how many pieces of legislation get passed through both the House of Lords, in this case, which initiated the legislation, and the House of Commons, and get the approval of the King? How many pieces of legislation go through in just a couple of months, 2.5 months? Hardly any. It's because there's no opposition to this. So other countries should get going. And we've heard from Luca, very fine presentation from Luca, how France is doing this. Well done. How Germany is getting it underway. The ICC Melita tracker, as it's called, shows 22 other countries are underway to get this legislation done. So, I mean, it's happening, but please, the message that I'm trying to convey to all of you, if you come from countries where your legislature has not yet addressed this issue, please urge the relevant authorities to do so. Okay, and why do I say legislature? Well, mainly it's going to be legislation that will be required. I know that sounds odd, and I could go into it, but I won't bore you with the detail. Mainly, legislation is required to make the changes that Melita has done, as Luca has rightly said. And if it hadn't been for Luca and his colleagues at UNCITRAL, we wouldn't have this great piece of legislation as a model to be implemented. Fine. There are, incidentally, and in addition, there are about 8 countries that are already fully aligned with Melita. So you've got about 30 countries that either are aligned or are on the way. However, even where you get the alignment, even where you get the legislation passed, just like here in the United Kingdom with the Electronic Trade Documents Act last year passed, there are other issues that need to be addressed, follow-up actions by either government and or industry. Some of these actions we've been speaking of, I mean, outside of law, but if I just concentrate on law, legal actions that need to be looked at. One is, of course, as you heard, there needs to be a reliable system at work to have the digital record that is being implemented by Melita. That digital record must come from a reliable system. And you've heard a little bit of a description of what constitutes a reliable system and how it may be illustrated. There's great work being done again by ICC and C4DTI, which I have to commend on developing what could be a reliable system. And it is also very much mirroring what is happening at the ICC DSI, as Pamela Ma yesterday in her presentation indicated, that there's an effort. Let's try and focus, let's try and give some guidance on what is a reliable system. Thirdly, some countries, in fact, have decided they want to use accreditation bodies. that would give an accreditation, if you like, a kite mark to a particular system that's being used. If you use that system, you can rely on it. It can be a reliable system. The second thing that needs to be done by countries like the UK that needs to round out the application of Melita in a proper way is to make absolutely sure that by practical and judicial means, cross-border recognition and enforcement will be permitted to foreign digital records, i.e. something that's created out in Asia or in Africa or where else. If it needs to be enforced here in the United Kingdom because of trade between the UK and those countries, you want it to be enforceable. You want that foreign, the fact that it's foreign should make no difference. Melita has a provision to this effect. Electronic trade documents has a provision to there is work very interesting that you should look at going on now by the Law Reform Commission of England and Wales, who developed the Electronic Trade Documents Act in a bill form. Very interesting work which they are doing, studying the so-called private international law issues of cross-border dispute resolution. What law should govern this electronic record? You can't even pick it up. I mean, in your fingers. I mean, what law should govern it, or what jurisdiction, what court should be given jurisdiction to resolve disputes? Now, we hope there'll be very few disputes, and perhaps in the trade area, there's a remarkably few in relation to the total number of trade transactions, because people want to trade. They'll settle their disputes perhaps through other ways than going to court. But when you need to go to court, you really want to have the confidence that you can sue to get the money if you're selling, or you can sue to get the goods if you're buying. There are other legal reforms too, which need to be probably undertaken in some countries. And I'm not going to go through them. I'm sorry to even have a sheet of paper in front of me, but when you reach this sort of a little reminder is helpful. Now, for example, areas like e-communications, e-commerce, e-identities, which we referred to yesterday, very important, and referred to even today, very important, and e-signatures. All of these things, the law may, in a particular country, give you great comfort on all of those things, but it may not. And in fact, in many, I'd say, emerging markets, consideration has to be given to some of those topics as well. Something further to facilitate. In other words, what I'm looking for here, legal aspects that need to facilitate digital trade. Finally, there is, of course, we've been speaking so much of the documentation, you know, the technical documentation, bills of lading, promissory notes, oh my goodness. Promissory notes, incidentally, in a digital form. No one's mentioned it yet, but may I mention it? If you want an example of a promissory note in digital form, just go to the Bankers Association for Finance and Trade, BAFT. It has a promissory note with standards. You can just take it off. They're open sourced standards. They're technical standards, not just written standards, business standards, but technical standards that I would suggest is an additional document that those of you wanting to use promissory notes, you could use. The big effort which is being done, though, on all these trade documents and the data that's contained in them is being done by ICC DSI. They are through, we heard of it this morning, but it's a fantastic effort, which will be formally released next week. In 1 week from now, we'll be able to look at about, I think it's about 36 or 37 trade documents and their data, the data elements of those trade documents, where you should go for examples on these so-called key trade documents and data elements work. which I strongly commend. But you see, it's trying to produce in a workable form the legal aspects. The final thing that I could say, and I'm sorry.
Can you do it in 30 seconds?
Yes, I sure can. Regulators have a key role to promote the digitalization of trade finance. And although you could say it's not a legal comment, it's a comment about regulators and their activities, I strongly urge them to continue to push in this. Thank you very much.
Thank you very much, John. I think we will come back to that because there's quite a lot in that might be worth discussing, but I do want to make sure we have some time for our last two speakers as well. So Luke has already mentioned some of the work that Vashti's been doing. So Vashti, perhaps you could introduce the Commonwealth Connectivity Agenda and the work you're doing.
Thank you, Guy. You know, it's really funny when Guy was taking down my name and what I do, he said to me, does everybody know what the Commonwealth Connectivity Agenda is? I'm like, chances are not. So he asked me to start off with telling you a little bit about what I do and why I'm even here as part of this discussion. The Commonwealth Connectivity Agenda was an agreement, a declaration made by Commonwealth heads of government in 2018 that there needed to be more affirmative action in promoting trade and investment towards the very ambitious goal of 20-30 trillion in Commonwealth intra-trade investments by 2030. Well, we'll see how that goes. But how do we do this exactly? We focus on 5 key areas. One of which, or the first, is on digital trade and digital economy development, as well as regulatory connectivity that looks at the entire regulatory landscape. We look at physical infrastructure, which I'll touch on very shortly, in terms of what are the bits and pieces that actually provide that connectivity upon which we can do any form of trade, as well as business-to-business connectivity, getting and engaging the business sector, because when the governments and regulators, we create the laws, who does the trade? The business sector, and they drive that global imperative. And last but not least, digital agriculture and digital fisheries. We work with all 56 Commonwealth member states. So unlike John, who has a reason of being old for having paper, I just work with so many people, I need to have a book. So we work with all 56 member states, and in doing our work, it is very clear, and even in the discussions over the last day and today, there is no doubt that particularly post-COVID, everybody needs to go digital in order to thrive and survive, particularly when trade. And even as we can see, there are global disruptions due to conflicts and other things. You find that the increasing digitalization of your trade processes build in that element of resiliency. In our recent report that we have done on the quantitative analysis of the move to digital trade, it was identified that the digitalization of trade could actually create value-added benefits of up to $80 trillion. But legal reform, just that one element, can actually reap benefits of up to 1.2 trillion by 2025. So how we see it, and in looking at how do you get this done across the Commonwealth, we see it as very basic building blocks. Now, looking at the UK ETDA and Singapore, my colleagues who are sitting there are countries that have done a lot of great things in terms of alignment with MOLITA, in terms of electronic transferable records. But you find that trade is a global concept. You just don't trade between 1 or 2 countries. Trade goes across the world. And as the trade economy or landscape is evolving, so too must our laws. So if you want to go digital, and then there's all this talk about, artificial intelligence and blockchain technology and IoT and big data, has the regulations kept up? And what about certain countries, like developing countries, that don't even have the basic building blocks? We recently did a legislative gap analysis within the Pacific, and we realized that a lot of countries don't even have a Data Protection Act. Needless to say, how do we figure out how does that align with other countries that have very strong data protection environments? So in order for trade to work, countries and their legislative frameworks, just as the interoperability of data, there must be a certain degree of interoperability with your legal documents, with your legislation. And that is, in a nutshell, why we're here having this conversation. So Melita is a very good example of a good model law. It's not very, as John has indicated, it's not very complicated, and even a technical person could read it and get it. But the objective is really to remove that barriers. And the promotion of Melita alignment by the ICC, as well as the Commonwealth, is to ensure that greater integration, because what we have seen, Martina's lovely maps has shown not just that some people have stronger laws and some people have weaker laws, but there is definitely a degree of incoherence between the laws across the globe. And when it comes to certain fundamental things like data protection, electronic transactions, how does that now correlate into doing seamless trade when everything is now in a digitalized environment? So that being said, we see the development of legal frameworks as one of the essential key building blocks, as with the other four areas that we work with. So one of the things that we are currently championing, and I know many of the stakeholders at this panel and others in the room may know about or become involved in, is the development of a Commonwealth model law on digital trade. It does not seek to reinvent a wheel because there are clearly lots of wheels on the ground. It builds upon certain already available legal texts such as Melita, as well as you would have noticed that there's another UNCITRAL Model Law text that is in relation to trust and legal recognition. And I know that there's another one on automation, but it builds on that because Melita deals with electronic transferable records, but it seeks to plug the gaps on certain other key sticking points, such as electronic signatures, data protection, cybersecurity, digital identity. And I will put a caveat on that because a model legislative text really just serves as a guide. Every country, and that's why we have different laws, has its sovereignty. Some may be more restrictive and some may be more open with regard to data flows. But why would we want to reinvent a wheel? It's because within the Commonwealth, we have a common history, or what we call a Commonwealth advantage, where we are based on common law. So what Luca had alluded to, that the Commonwealth countries, you seem to find are faster movers. So out of the countries that have adopted Melita, 5 of them are Commonwealth. And that would be Singapore, the UK, Belize, and recently Papua New Guinea, PNG. And you find that it's easier to get traction because you have that common basis of law. We're also common trading partners as well. But this is the intention behind it. We're currently doing work actively on it and actively involving the industry in terms of the private sector to get their direct feedback on what are their priorities. But also we do have the legal task force comprising of chief legislators from all the different countries that will now identify whether this is workable, this is something that is doable and implementable. So before Guy gives me the 30 seconds, I am just going to hand back over to you, Jay.
Thank you very much, Vashti. I want to come back to this, and I hope that by now you have all realized that there is an unstoppable force behind all of this. But Vashti alluded to some of the other benefits, and I think that's a good segue into what we're going to hear from Dr. Mambion, which is actually really what those practical and economic benefits are. And I may come back to this because as someone who practices in the world of international arbitration, the countries have embraced that harmonization, and a model law approach have really benefited financially. And I think it's important for people to understand that actually you don't want to be late to this, you want to be early to this. So Dr. Mambion. Dr. Mambi, you're on mute at the moment. I'm hoping that that's only temporary. Still on mute.
Okay. Can you hear me now? Yes.
Yes, we
Thank
can.
you very much. I won't have much to say because much has been covered by my colleague speakers, especially Vashti from the Commonwealth Connectivity Agenda. Now, she mentioned about the possibility of developing the model law on digital trade, that is the Commonwealth model law on digital trade. So I'll just highlight what are the key issues and the principles that are covered by the proposed model law. And this has also been highlighted by Luca. So we should understand that under Commonwealth now, we have both countries that use common law and civil law, like some countries, because we have 56 countries. Now, the proposed model law will cover both principles from the common law perspective and the Commonwealth perspective. So some of the issues that are going to be covered by the model law include secure electronic signatures that include digital signatures. So we sometimes confuse between electronic signature and digital signature. So these are the issues which are different that will be covered. So the model law will give legal validity and certainty on the use of electronic signatures in digital trade. The other area is electronic payment, as we are all aware that digital trade involves payment electronically. So again, the model law will give legal recognition on electronic payment. And the other issue is consumer protection online. That will also be covered by the model law. And here we'll be talking the rights of consumers who are buying goods online and what are the obligations of suppliers and service providers online. And the other issue is electronic contracts, formation of electronic contracts, because sometimes, in most cases, digital trade will involve contracts that are formed electronically. So those contracts that are formed electronically will be legally recognized by the model law. And of course, the legal recognition of electronic transferable records and instruments like bill of lading, then now the model law would give legal validity on electronic bill of lading and other related documents. Now, the other issues that is going to be covered or that are going to be covered by model law on digital trade is the question of cybersecurity and data protection. We are all aware that now some countries or most countries, they have cybercrime laws and data protection laws. But now the issue is, are those issues related to cybersecurity and digital trade covered by the laws, like spams, fraud, unsolicited communication, identity theft, phishing, and other related issues? So the model law will address all issues related to cybersecurity and data protection, data which is highly confidential. The other area is digital identification, which will also be covered by the model law. Of course, the model law is going to be a very wide document. It will have like 7 parts. And it will also cover other areas like jurisdiction or dispute settlement online. Maybe the question of electronic taxation or cyber taxation can also be addressed. So those are the key issues that is going to be covered by the model law. But now, like Malita or later, the model law will also cover the key principles on digital trade. These principles have also been mentioned by Luca. The principle of functional equivalence is the model law will give legal or equal status between paper-based transaction and paperless transaction. This is functional equivalence. And there will also be the principle of non-discrimination. This is a very cornerstone of the model law. We'll also have the technological neutral approach. So the model law will be technological neutral. For instance, now we are talking of artificial intelligence. It is today's technology. But after 4 years, you can have artificial general intelligence. So the model law will not cover the specific technology. it will cover today's technology and tomorrow's technology. So that is the whole question of technological neutrality. And other principles, the model law will also be very flexible, as mentioned by Bishad, that countries will be free or will be at liberty to adopt the whole or partly provision of the model law. So some of the issues, or most of the issues from Malta will be adopted under the model law on digital trade. But this model on digital trade will go further, because unlike Malta, which mainly focuses on facilitating electronic transferable records, the common law model law on digital trade goes beyond addressing other issues, as I mentioned, such as electronic contract, cybersecurity, data protection, electronic payment, and other related issues. So those are the key issues that are going to be covered by the model law on digital trade. As I said, this document will be very detailed. So because in the interest of time, I can't cover everything, but those are the areas I thought very important to be covered by the proposed model law on digital trade. Thank you very much.
Thank you very much, Dr. Mambi. I may come back to you on your prediction as to when we'll have artificial general intelligence, but that's probably for another session. I'm hoping we've got time for a couple of questions. I'm looking for a nod at the back that that's okay. If we have any questions. So let me, while you're all thinking of your questions, let me pose one, and I'll open this out to everyone. John, you talked about other regulatory changes that might be needed to support this. And one thing you talked about is what happens at the back end. I mentioned at the beginning, arbitration. Isn't that a solution? Because arbitration brings with it a great deal of flexibility. So if you bring, frankly, two model law principles and bring them together, doesn't that create something of a solution? Because that theoretically cuts through a lot of the recognition issues, because that would then come up through, frankly, an international model that already works, backed by the New York Convention on Recognition of Arbitral Awards.
Yes, it would. I think arbitration certainly helps a great deal. I suppose it does depend on whether the parties consent to arbitration. So it would be needed. Perhaps one should include within the data that is captured a consent to arbitration. And indeed, as we all know, arbitration is used very, very widely in international transactions for the very reasons you've been suggesting. So it could be very, very helpful. It would still, I suppose, the issue would become whether the parties had given their consent in a proper fashion and so on, but it would avoid some of the issues that I mentioned.
Well, we can have entire conferences on consent and arbitration, but we'll save that for another day. Any questions from the audience? Yes, we have one over here. Thank you.
Thank you. Just to follow up on your question, isn't an issue with arbitration the lack of binding precedent being created, and also the fact that arbitral awards are very rarely published, so that we wouldn't have a body of knowledge, so to speak, growing up around these new practices?
Well, as an arbitration practitioner, let me answer that. In my experience, the only people who are interested in precedent are lawyers, and the people who are interested in getting their disputes resolved efficiently are business people. Now, there is an issue there, but actually a lot of the institutions are now publishing versions of awards that remove confidential information, so that there is some degree of material that comes out. And I think actually what we will probably see is more of that, not less. I had one question, perhaps to finish, if I may, Nick. And that's sorry about this, but I was very careful. I noticed the time that we started at 17 minutes past. So technically, I think we still have 2 minutes. And it's this question, and it relates to the economic benefits of this. And that is, if you look at arbitration, sorry to raise this again, the jurisdictions that have benefited from arbitration have been those who embraced it early. So France, the United Kingdom, Singapore is really ahead on this as well. And what's really interesting is how countries, new countries that are looking to get into this in a big way are investing serious amounts of money in it now. Look at Saudi Arabia. So the question is around this is, what would you be saying to a country that is looking to embrace Melita about, how do you persuade them that actually you need to be at the front of the queue, not the back of the queue? What are the key issues? And I'll open that to any of you.
If you want to pick it up, or no, well, like this area is not really. I don't focus very much on customs. So, but I guess like what you mentioned makes a lot of sense. So to be the early adopter, but finding something like a Commonwealth working together on it creates much more mass and critical mass to give a sense to this, because anyway, trade is always cross-border, so you do need more than one country working together, and starting from something like the Commonwealth, I think would be quite interesting.
Vashti, final words?
Yes,
Dr. Mambi, you go first and then we'll hear from Vashti.
The economic benefits.
Yes, I just,
there.
okay.
And
Yes,
think
I just wanted to.
Go ahead. There's a slight delay, Dr. Mambi, but you go ahead.
Yes, I just wanted to add on arbitration. You mentioned a very crucial issue on arbitration as far as digital trade is concerned. In my view, I think we also need to consider involving electronic arbitration under the model law or our laws, where you will have electronic arbitrators and electronic mediation. So because we are talking digital trade, we cannot avoid using electronic arbitration and electronic mediation. That's what's my point. Thank you.
I couldn't agree more, Vashti.
All right. So the economic benefits are very clear, as not just the quantitative analysis, but even the recent report that was published by the ICC in relation, and it contained actual clear business cases. I think it was showing that in traditional methods, it took 200 documents to move a crate of roses from one part of the country or one part of the world to another part. And then there were actual cases that showed that post-ETDA, companies cut that time down significantly from months to days. Yeah. And not only that, the costs were streamlined, which allowed them to do it at greater scale, but also to allow for less delays in terms of even payments for each member along that supply chain. So the economic benefits are there. And therefore, how do you link that to the legislation? It creates the ease of doing business. It's that foundational platform that says, do business. We're removing your barriers. We're making it very easy, which is the last thing you want to think about. Trade itself is complex. So why not create that enabling environment? And it costs to you as a government. What does it cost a government to change their laws? Yes, there's the human effort of the lawyers and all of that good stuff. But in terms of the long-term benefits, the economic benefits are very clear.
Thank you very much. I wish we had more time, but I know that I'm actually keeping you from your coffee now. So can I ask you all to thank our speakers in the usual way for their really excellent contributions?
Thank you very much, Guy, and the panel. So, right, we'll be on strict limits now because the Minister will not tolerate any delay. So, we will be starting direct on the dot of 25 to 4 with the first presentation of the people who are going to make your digital journey real. So, you want to be back in your seat, please, by bang on 25 to 4.
Well, thank you.
Thank you.
Lovely. Oh, so nice. I'm very pleased to meet you.
Thank you very much.
Oh, thank you.
Thank you all. That was
Yeah.
great.
Yeah,
I really enjoyed that.
Yeah,
Really.
yeah, great. Nice. Yes, thank you.
Thank you.
Yeah, well,
Yes, well done. Thanks very much, everyone.
Sorry about
It's always the same way, isn't it? We could do it another hour, really, couldn't we?
No, but I think. Oh, yeah.
You're absolutely okay. I'll let you know.
Thank you.
Thank you, Dr. Mambi. Appreciate
Yeah.
it. I'm going to get. I'll be in touch with you, by the way, about electronic arbitration, because that's something else I have interest in.
That's very important to facilitate the digital trade.
Thanks very much.